unlock the secrets, learn new tactics, and build a winning strategy to win the aging game. Welcome to the Aging Game with Bruce and Susan.
Welcome to the Aging Game with Bruce and Susan. This is episode 6, Getting Your Ducks in a Row, which is all about legal documents with local elder law attorney Ed Wollman.
Hi there. Hi, Susan.
Hi, how are you?
Great. Nice to see you.
Good to see you.
So, what have you been up to?
Well, I've just been staying busy. Obviously, we're about a month in of having our episodes out, so it's been fun working on that and seeing us grow our audience, as well as at Bright Star, I've been working on the guide pilot that we're launching. So just been staying busy with those two things. How about you? What have you been up to?
So, they said the summer's supposed to be slow, but I have not been slow. The matchmaker has been very busy out there. So life has been very busy and helping a lot of people find the right place. So I've been very busy. I'm trying to squeeze in some tennis here and there. So playing a little tennis and, of course, some barbecue.
Well, I love that you're getting some fun in there. So I know we've got a great topic today, and I know you've got a story to share with us to kind of get things going.
So my story is personal. So my dad was a very successful psychologist, had a very successful practice, and accumulated wealth. And he had a very bad condition of analysis paralysis. And, he would gather all this information and he couldn't make a decision. And it overwhelmed him. And not only did he have analysis paralysis, but he had another condition called denial. And the combination of those two things prevented my dad from making a plan. And my dad passed away, and instead of his estate going to our family or to a charity or, to whatever he wanted, we wrote an obnoxious check to the government. And, it's just a horrible thing that occurred, that here's a person who worked his entire life and couldn't pass on his estate to his family. So it's bad. So yeah, that was my story. So very personal, but I think it's relevant to our speaker today.
Absolutely. I think it really sets the tone. And I love that analysis paralysis. I think that that's a great description of what people encounter in these things. So, I love to share statistics, especially on the topics we're going to discuss today. So I've got a couple that are interesting today. So there was a study that caring.com did with the National Institute of Health, and Gallup surveys. And they did this between 2022 and 2023, and they published it earlier this year. So their findings were that 64% of people surveyed said having a will was very or somewhat important to them. However, only 32% of them stated that they had a will or an estate plan in place. So wow. I thought that was quite shocking. Another aspect of the study was 38.2% of Americans have some form of advanced directive in place, healthcare, POA, or living will, but don't truly understand the differences. 43% stated that they would make a will after a serious medical diagnosis or health condition. And 40 cited that cost was a reason for not having these legal documents in place. I thought those were all really interesting as we think about this, and this is such an important topic.
So interesting. I think today's topic should just be called analysis paralysis.
Absolutely. We're renaming the episode for sure.
So as we dive into this topic, just want to kind of tie it back into our overall theme of chess. And so I found a quote which I thought was interesting, that in order to improve your game, you must study the end game before you can do anything else. So the thought is, what is your end game? What do you want at the end result? So
great quote, and definitely ties into our theme and what we hope for our listeners to get out of today.
When experience matters the most, Senior Housing Solutions uses over 30 years of industry knowledge to provide expert advice for those considering a move to a senior living community. We are the matchmakers of senior housing. Call today at 239-595-0207 for your free consultation.
All right, so welcome to the Gambit, as we call it. Today we have with us Ed Wollman. He is the founding partner of Wollman, Gerke and Associates, which is a boutique estate planning firm here in Naples with over 30 years of experience serving the community. He is board certified in wills, trusts, and estates and holds a Master of Law in Taxation and is a chartered advisor of philanthropy.
And he's a good friend. I've known Ed for many, many years, probably over 20-something years. So he's a good friend. We're thrilled to have Ed on our show to share his daily experiences working with clients to help them navigate through the complex decisions surrounding senior living options and long-term care needs, estate planning. So Ed, thank you very much for being here.
Great. I look forward to the conversation. Thank you, Bruce.
Thanks. Well, before we get started, I like to always ask the same question. So what is something that you know today about the topic we're going to discuss today, so all legal planning, that you wish you knew earlier either in your life or your career?
I think since I've been practicing for almost 40 years, I've learned a lot of these things along the way. So I don't know if I learned them this year or I learned them over the years, but speaking in plain English, I think a lot of the analysis, paralysis by analysis or analysis by paralysis, I think that has to do with people really not understanding their options. What's wonderful about working with Bruce is he's a gentle giant. If you've not seen Bruce in person, he's extremely tall, and his personality goes along with that. But he's very soft-spoken. He speaks in plain English, and he makes it really easy to understand your options when it comes to senior living. So when it comes to estate planning, you could imagine how much jargon there is. So through a very dear friend of mine who was first a client and then a consultant, her name's Terry, she taught me to speak in using plain words, not the jargon that we think everybody understands, like generation, skipping, tax, exemption. To me, that's obvious what it means, but for a person who is not a lawyer or even a lawyer that doesn't practice in the estate planning arena, it's really difficult. So the main thing is slow down, be a much better listener, which is very difficult for lots of reasons, because I don't want to be critical of men and lawyers, but slow down. You don't know everything. Listen to what is the end game, as you and Bruce just pointed out, the chess game, and find out what the goal is. Once you've done that, in order to get to the finish line, I think it's extremely important that you lay out step-by-step, easy instructions on how to do it. And I'll say one thing about your opening. If you don't have a large estate, more than a couple $100,000, I would say, at least do the basics. You know, if you don't come to an attorney that knows what they're talking about and you want to try to do it yourself, it's difficult to do it yourself, but there are options out there that are very inexpensive, like the LegalZoom, Vanilla, etc. And they're not bad. The problem is you don't know what you're filling in. So it's really good to work with a lawyer that will help you. We don't particularly do that, but we do meet people where they are.
I love that you mentioned being simplistic for the people you're working with to understand it. Even as we were writing our notes for this episode, you know, we're so used to acronyms and different things that are common to us, but to the average person, we understand they might not understand them. So taking the time to even just break those down is really important.
And what's interesting about the average person is that there's nobody that's average, as Bruce would say. None of my clients, you know, the average stay at a nursing home is 3 years, but none of my clients are average. I've learned a lot from Bruce. But in terms of the intelligence of our clients and the population out there, they could be a practicing attorney in real estate, corporate, and they might not understand estate planning either. So one of the misconceptions that we'll talk about later is that just because you're a lawyer doesn't mean you understand elder law and long-term care. This is a subspecialty within estate planning. So it's very important that you work with somebody that understands and works extensively in this arena.
Great stuff. You know, we talk about building your life plan or building your blueprint. And what would be your advice on when someone should start thinking about their aging strategy?
I hate to quote Bruce Rosenblatt one more time, but he said all the time to his clients, it's better to be 5 years early than 5 minutes late, because if you're already incapacitated, you can't qualify for some of the wonderful places to go live. Same thing with estate planning. It's better to be early and then revise your documents later on, because these are I can change my mind documents, so you can change your mind later on, than to wait and say, I'm not that old. I don't have that much money. I really don't need to do it yet. The answer is you absolutely need to do it yet, because you never know when something might happen, as they say. You can't plan for that. So you need to get in early and get the plan in place and then revise it when you review it over the years.
Really good points. When I was going through the statistics, I chose to include the last two I did because I found them so shocking that a vast majority of people were concerned about the financial aspect of creating this, knowing that there's a ton of resources out there. Even if you're creating something basic, just wanting to protect your family seems so important to me. So that really was one that stuck out to me. As we get started, one of the things I wanted to start with is what I see in my industry a lot is people will say to me, oh, yes, I have a power of attorney. But I don't know, if it's active, or I don't know if it's, healthcare, financial. I have one. And, I'd love to, dive into that a little. Can you break down for our listeners the differences and, what does it mean to be active versus not active? And once you have one, isn't it active?
Every state is slightly different. I mean, a lot of them are similar, but in Florida, your financial power of attorney, it's a durable power, so it lasts. If you become incapacitated, it doesn't stop. A regular power of attorney stops when you become incapacitated. So we have a durable power of attorney, but it's effective immediately. So you have to select somebody you trust, and you're giving them that strong power to put your pen in their hand so they can do financially what you could do, including possibly changing your documents if that's how broad your power of attorney is. So basically, the modern day durable power of attorney gives you many options, including giving the person you trust 100% authority to make the necessary changes if you need to go to a nursing home or if the tax laws change. So it's very important that you work with a sophisticated person on designing the power of attorney. Again, it's a price situation, but I think it's really important. I think it's one of the core documents versus the power of attorney for healthcare. In Florida, it's called the healthcare surrogate. Healthcare surrogate means they step into your shoes and make medical decisions for you when you're not able to speak or write. If you could speak or write, you get to continue making decisions for yourself. But if you can't speak and you can't write, then you've already named somebody. And now the new law states that it's effective immediately, whereas the old law, you had to wait to get a doctor's note. So the new healthcare surrogate over the last 5 to 10 years has changed, which is really important because doctors don't like to say you're incapacitated. They don't want to go out on the limb and say that. So it's really important you have modern healthcare documents and modern financial documents, including a durable power of attorney.
And so just to be clear on that, so if someone had a power of attorney, it only becomes active when they're incapacitated? So
no, the other way around. That's called a springing power, and other states allow you to have that. In Florida, they don't have a springing power because they don't want people to negotiate, oh, the person's incapacitated, they're not incapacitated. So the power of attorney in Florida is effective as soon as you sign it. So you've already given your spouse or your children or your dear friend or your sister or brother, you've already given them the power to act on your behalf. So you must trust that person. We as a law firm keep it in our safe, and we do not give it out unless there's a darn good reason.
So if I added my sister as a power of attorney, she could go right now and
Empty your bank account.
empty my bank account.
Correct. Not legally from a point of view of theft, but definitely physically, because that's what the power of attorney says.
Interesting.
She's not supposed to do things in her own benefit, but you
And
can't control that.
and the medical power of attorney, when you say someone has to speak, could they be nonverbal speaking?
They could write or they can speak. They
Can
have
they
to be
like
able
blink
to
a few
communicate.
times, or
That's not what the document says. I assumed, and I think that would probably be acceptable if you could communicate with them in other format. But theoretically, if they can blink, unless they're completely incapacitated physically, they probably could write, or at least check the box.
right? Interesting. And when you're developing these documents, how involved should family be?
Usually I'm just dealing directly with the individual, so there's no undue influence, or I want to be able to make sure the person knows exactly what they're doing on their own. If they want to bring a family member into the mix, I don't say they cannot do that, but I rather them have the capacity to make those decisions. Often after the fact, they'll show it to their children and go over it with their children.
Interesting. And do you recommend that the family member or that person is the same person for these different roles, or is it better to have different people for these different roles?
Typically, the one that makes healthcare decisions is the one that's closest to the field, or stereotypically, it's a daughter. That's very stereotypical. I'm not saying that's right or wrong. That's just typical. Same thing with the financial. Typically, it's the oldest child, and often the one that's closest to the financial business. And the client feels that they would be able to handle difficult financial decisions if they could not handle it themselves. So typically, the healthcare and the financial is not the same person. Many families that are very, very close with their children might have two children, and they might choose both children for both roles to work together as co-healthcare or co-financial.
I'm sure that gets interesting.
Yes.
Sometimes.
When they say they want 3, I usually shut it down and say too many cooks in the kitchen. But I'll say to them, this is your decision. Who do you think would show up and be there for you if this took place?
Good stuff.
Definitely. I think the documents can definitely be confusing and complex, as we've touched on. We've talked a little bit about the difference between power of attorney and then with the financial and the healthcare surrogacy stuff. And then, guardianship kind of ties into that. What I see with clients in my specific industry is they will come to me and they'll hand me one of these documents, and they think that encompasses A to Z, that they're in charge of everything and making, all decisions. Or they think, oh, well, I have this and that trumps guardianship. So can we just talk a little bit about how guardianship might play into this?
Yes. Also, you have to remember that your patient/client is still 100% in charge if they're communicative. So just because somebody has a power of attorney for healthcare, or a power of attorney, we call it a healthcare surrogate, or a financial power of attorney, doesn't mean that they can trump their parent or their sister or brother. So it's very important, because often they'll say, oh, I'm in charge. My mother or father doesn't really know what they're doing. And if they have not been declared incapacitated, they're still in charge, and they can still revoke and change those documents. So it even gets more complicated. Not only, to answer your question, should the documents be very complete and thorough, but also there's a timing issue. I know that I've seen it up close and personal, that people will think, hey, I'm in charge of medical. Well, you're not really in charge of medical. The client is, the patient is.
Very interesting. With the different options that are out there, we definitely know that, we encourage people to start all these conversations soon and have these at an early plan. When do you think that someone should decide, what type of option is best for them? Or if they have these documents in place, how often do you recommend that maybe they review them, or in what scenario should they make a modification?
It's very age specific. If you are young, then you're probably going to set these in place and look at them every 5 to 7 years. Unless there's a major change in the law, which your law firm will probably send you a newsletter telling you to come in for a change in the law. Otherwise, if the client is older, say in excess of retirement age, then they're probably going to have a very serious conversation with their lawyer and financial advisor and all the other planners that they work with, and probably revisit the situation every 3 to 5 years. We send out a quarterly newsletter. It probably goes out about 3 times a year. But we send out this newsletter and we keep people abreast of the changes of the law. It's not our obligation, but we feel it's a responsibility to at least put it out there and say, hey, it's time for a recap. And then if we don't hear from you for quite a while, we send a reminder letter out that says, hey, it's been a while. Have you had any major change of circumstances? Somebody gets married, somebody gets divorced, somebody's sick, somebody has special needs. We really need to know about this, and we can't get it from you if you don't tell us. So it's really important that you communicate with your advisors.
Need to have that team. There's a lot of confusion about living wills, advanced directives. Can we talk a little bit more about and define to our audience what these really are?
So advanced directives are exactly what they sound like. You are making a direction in advance of you needing it. So since you made the direction in advance, you're taking off the burden and the guilt of somebody to make a very, 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 very difficult decision to, say, discontinue life support or never to use life support in the first place. So the idea is, because these are advanced directives, while you had capacity, you've already sat down with your family and decided, hey, if I turn out to be in this condition, I don't want to be kept alive by putting food and water through a tube, that if it's only going to prolong the pain and the dying process. So please, I don't want to live like that. Please think about what I said. And even though I know you'll feel that it's a difficult decision, I've made the decision in advance. In the case of a living will, it takes 2 doctors, one inside the facility and one outside the facility, to sign off. That way they're not continuing to provide care, which is very expensive, or the opposite. They're not discontinuing care because they feel like, hey, it's too late. So it takes 2 doctors to concur. Then they turn to your healthcare surrogate and they have to sign off as well. So there's quite a process in place. So I hope everybody signs a living will authorizing these people to make decisions for you as the patient when the time comes.
I'm sure everybody remembers the Chavo incident where there wasn't these documents in place. And
then it's very expensive, very time consuming, very emotional, and that's not fair to your family. But most people sign them rapidly because very few people want to be kept alive. I've had 1 or 2 that says, nope, do everything you possibly can. I don't care. But most people sign the document. I'd say 97, 98% of the people sign the living will.
So thinking of that whole topic and, do not resuscitate orders or DNRs, where do those fall into that?
Good question, Susan. The DNR, the client always thinks that the lawyer gives them the do not resuscitate order. That only comes from the doctor. It is not the same thing as a living will. So I've heard a doctor who was also a nun speak around 20 years ago. And without a DNR, they will still resuscitate you because they can't make a legal decision as to whether to do it or not. So if you have a DNR and they know about it, it's on your refrigerator, or it's on your wrist, or it's whatever, tattooed on your chest, then they're not going to resuscitate you. Otherwise, her comment was, you're resuscitatable until you have that DNR.
Very interesting. I have this scenario a couple times that comes up where we have clients that are seasonal. So they'll come down here, and when we meet with them, we, obviously talk about these things and incorporate them if they're, a do not resuscitate or a full code or whatnot. And they'll bring documents from other states. And I always tell them that, they need to have that by a Florida doctor. That's a requirement for us, and put that on there. But they don't always listen to me.
Right.
So what's some advice I could maybe give them?
There's good news. The good news is the statutory provision says if the documents were valid when executed in that northern state, that they're valid here. I am not aware of the rules pertaining to the do-not-resuscitate. That I would want to have a doctor's opinion on, and I could look at the statute, but I don't know the answer to that. But as it comes to the living will, healthcare surrogate, durable power of attorney, those are all accepted if they were validly executed. I still think they should have Florida documents if they spend more than a few months here a year, because you don't want somebody having to go to their legal department down the hall to find out whether your documents are valid or not.
So I think that's a great piece of advice, is that if you are down here, you should really have them Floridaized, I guess would be the proper term. So what can you tell us about misconceptions? I'm sure you see a lot of it within your industry. Are there some misconceptions that you see that you would want to dispel to our listeners?
I think the most important one I mentioned earlier, and that is that anybody can do this. It's a real specialization to know how to deal with these subtopics of the legal community. So just because you're an attorney doesn't mean you know whether to use this document or that document. Another misconception is that the best laid plans of mice and men. You really need to work with your family on your health care decisions, because when the time comes to do these things, like to move to assisted living, very few clients actually want to follow their own advice. So I think you should have a plan that's done while you're healthy and capable. And that's why I love what you do, Bruce, once again, and that is visit these places that you may have to move to early. If you have a tremendous amount of money and you plan on staying home no matter what, you have to realize it can be $25,000 to $30,000 a month per person to stay at home with round-the-clock care, and that doesn't cover your other housing costs and food and insurance and everything else. So plan early and plan often is the opposite of the misconception, which is everything's in place. Or another misconception is I have estate planning documents, so I'm going to avoid probate. I'm going to avoid lawyers. I'm going to avoid the cost of dying or becoming incapacitated. Absolutely not. I'm here to tell you it's very difficult to avoid probate. But the most important thing in terms of getting your ducks in a row, bringing it back to what we're talked about as the topic today, or analysis by paralysis, your advisors need to know how your assets are titled. Because just because you have excellent estate planning documents, if you don't title your assets properly, they could pass pursuant to the financial advisory firm's directions, not your will and trust. Example, you have a beautiful will and trust that protects your children and grandchildren, yet your financial advisor says, who do you want all your money to go to? And they have you sign a simple one-page piece of paper called a TOD, transfer on death, which obliterates your estate plan. So please do not fill out TODs without knowing exactly what you're doing. If you want to use a transfer on death at the financial institution instead of running the money through your trust and through your estate plan, that's fine. But realize you're obliterating what's in the documents by not using the documents. Instead, you're going outright to those individual beneficiaries.
So it's interesting you bring that up. When my mom passed away and I was the executor of the estate, she had a checking account, and the checking account was not in my name, even though I was I had POA, it wasn't in my name, and I couldn't touch that checking account. And they said, well, do you have TOD, transfer of death, on it? No. And so we had to go to probate to
that's
open
a shame. So on your small checking account, your household checking account where you write the majority of your checks, or your debit card is connected to it, or even your brokerage account could be connected to it sometimes. On that, you either want to add a second signer, so a co-person on it, like your son or daughter, or obviously your spouse, or have a POD, pay on death, to either your trust or pay on death to all of your children or pay on death to the one child that's going to be paying your bills.
That would have been helpful for my mom. And so talking about trust, is that complicated? Is that process complicated to develop a trust for somebody?
The actual paperwork is quite easy. Again, what's complicated is, should I put my assets in the trust just because I have a trust, or should I keep them in joint name with a spouse? So funding your trust or not funding your trust, I have an article. If you want it, just call me. It's sort of like to be or not to be. That is the question. And the article is to fund or not to fund. Because if you're a husband and a wife with the same children, you've been married a long time, and you want everything to go to your spouse, by putting in your trust, it's not going to your spouse. It's in trust for the benefit of your spouse, but then you have the legal costs of maintaining that trust. So if you really want the assets to go directly to your spouse, then you're going to want to keep them in tenant by the entireties, so that it passes immediately to the spouse upon death as opposed to going through the trust. So it's very tricky. Please talk to your advisor about funding or not funding.
I know, I remember your presentation, and you, I think it was, you had a bunch of buckets.
Right.
And I think that's probably part of this whole process.
Yes.
Is how do you want your buckets positioned?
Right. And when do you want to fill those buckets? Now, or when a spouse becomes incapacitated or a parent becomes incapacitated, and then you could use the durable power of attorney to fund those buckets during their incapacitation.
And I know Susan and I are pet lovers. And so have you seen people put money aside for their pets?
My favorite one was when we put $75,000 aside for Simba. And then when Simba died, the money, if there was anything left over, goes to the daughter-in-law. So Simba was ahead of the daughter-in-law in desire. But we often do pet trust. Florida made pet trust legal about a dozen years ago. So we often will have a pet trust that says, I want this person to take my animal or animals, and I want them to have X dollars either per year or a total lump sum. And then if there is any money left over, it either goes back into the bucket or it goes to the caretaker.
I'm going to make a educated guess here that there are 5 cats ahead of me that my mother probably has named.
Right. Her and Leona Helmsley, who I think tried to leave $12 million to her animals.
Yeah, I'm sure they're all taken in position ahead of me. And rightfully so. Those are her
Yes.
24/7 bread and butter love babies.
Yes.
One thing you both mentioned was probate.
Right.
So we hadn't talked a little bit about that. Can you explain that for our listeners and, kind of what that is and how that works?
Sure. A trick to the trade is, if you have to open your will to determine where something goes, and you have to read your will, then you have to go to the judge and say, is this will valid? That's the probate process. So if everything passes outside of that, because it's either in joint name or it has a beneficiary designated, then it avoids the probate process. That isn't always what you want, especially in a second marriage, or especially if you want the money to go into trust to protect your children against divorce and lawsuits. So it's really important that you, again, have that funding conversation as well as this conversation about probate.
So this is an extremely complex topic. And
Sorry.
No, it's great.
Yes.
And I think, Terry has helped you make it very easy for everybody to understand.
Right.
So we appreciate Terry and all,
Yes.
her wisdom with this.
Thank you, Terry.
So Ed, is there something that, like a piece of advice? I know we talked about analysis paralysis, but is there some advice that over your 40 years of doing this that you'd really want to share with our listeners about, what do you want people to walk away with from today's topic?
I think a better understanding, like you said earlier, a better understanding of what you have. A lot of people have great documents, but they don't really understand what they have. You go to a doctor, and I heard, using Susan's statistical analysis, I heard you, and this is true with every complex topic, you retain about 50% by day 2, and you retain about 25% by day 3. So when circling your advisors together, you really want them to explain with you, to you, for you, what you have in a way that you could retain it for more than a day and a half. And that's a problem. When my most sophisticated clients don't know whether they have a revocable or irrevocable trust, that's a problem. So as we learned along the way, thank you, Terry, I can change my mind is revocable. I cannot change my mind is irrevocable. So it's sort of like, please understand what you already have. And if you have a wonderful plan in place, you might want to have a checkup just to say, hey, could you please explain to me once again what I have? And the other thing is get all the advisors in the room at the same time. Mm-hmm. And people don't really want the lawyers in the room or the accountants because we charge by the hour, whereas they think their financial advisors aren't charging because their fees are buried in the cost of managing the money, et cetera, et cetera, et cetera.
Good advice. What would you say is the most common mistake that you see people make in this process?
Not following their own advice, not following either the funding or the lack of funding, basically not titling the assets properly, and then thinking it's all taken care of.
Wow. Very impactful.
And if people are interested in learning more about your services, how can they reach you?
So we have a website, probate-florida.com, spelled out, probate-florida.com. Has a tremendous amount of resources if you're a self-starter. Otherwise, you can just call the office, 239-435-1533. We have 9 estate planning attorneys. We're a small boutique. We're kind of a well-kept secret. I've been here for over 30 years in Naples, and we have a great staff.
I love that. This is such great information. I know we've covered a lot. Is there anything that you think that we haven't touched on that we should share with our listeners?
I always cover 2 things as people are leaving my office. Do you have umbrella insurance? Because one of the things that can devastate your estate is if you're sued for a car accident. So everybody should have umbrella insurance, which we don't handle. Of course, you get that through your property and casualty agent. And long-term care insurance. You might want to self-insure, but you should talk to your financial advisor or ask us about it. You want to know, should I pay for long-term care insurance in advance or should I self-fund? And then the third thing is to plan ahead, as we said, get with Bruce Rosenblatt and find out what are your options regarding living. Where do you want to live? What's your plan? Are you going to stay at home or are you going to try to find a beautiful place to live that's not at home?
Ed, you've been great today. Thank you for all my plugs. So I really appreciate that as well. But you've been great. Great to see you.
Yeah.
Thank you very much.
You're awesome. Thank you very much. And thank you, Susan.
Thank you so much for being
here.
Your
organization is wonderful too. I've worked with your organization. So if they don't already know who that is, you can fill them in. But we work with all the different agencies in town. We have to. But your company has done a great job.
Well, thank you for saying that. I always encourage everybody to explore all the options that are out there for home care. I obviously would love for Bright Star to be the choice for everyone, but I want everyone to make the choice that's best for them. And sometimes that's someone else. And I'm okay with that as long as they're getting what meets their wishes and their wants. So I love that you have a wide variety of connections.
Thank you.
Bright Star Care of Naples and Fort Myers, providing exceptional in-home care. At Bright Star Care of Naples and Fort Myers, we believe that you and your loved ones deserve nothing but the best. Our team of highly trained nurses and caregivers are committed to delivering the highest standard of in-home care. We offer a wide range of both medical and non-medical services to cater to your specific needs. From companion care and personal care to skilled nursing and therapy services, our professional care team is here to meet your needs, both now and in the future. Bright Star Care is proud to provide the highest quality of care and prioritize in-home safety. We are accredited by the Joint Commission, and all care is overseen by a registered nurse. With Bright Star Care, you can have peace of mind knowing that your loved one is in the best hands. To learn more about Bright Star Care of Naples and Fort Myers, visit us online at brightstarcare.com or give us a call at 239-992-4779. We are available 24/7 to answer any questions you may have. Bright Star Care of Naples and Fort Myers, where exceptional care meets compassion. Locally owned and operated since 2006.
All right. Well, welcome to our final segment, the checkmate. As we wrap up today's episode, Bruce, what is that one thing that you had as a takeaway today that you just think is our, if they do nothing but this one thing, what is it?
I think the takeaway is plan early. I just truly think that is something that's critical in this entire process, is that people need to meet with their attorney, meet with their financial advisors, meet with their family, and take denial off the table and develop a plan. And to me, that's the most critical part of this, is that things are going to happen. Things are going to happen unexpectedly, and you better have a plan in place.
What about you all about pre-need? Do you all suggest pre-need for funeral arrangements and things like that?
Tell us about it.
Well, it's just pre-need is something you don't have to pay for, but you go to your favorite or the one that's recommended funeral home. If you're going to use cremation, there's a lot of societies that you can call up, and you make arrangements ahead of time, because it's very frustrating and very expensive. So if you don't have time to think about it, when somebody dies and you have to make arrangements in the next couple of days, that's horrific. So it's called pre-need planning. It's called pre-need. And you set that up ahead of time. You can either pay for it in advance to lock in the price, or you can leave it open and just take whatever price it is at the time.
And what a great thing is that, you have everything pre-planned, and you can put it in a little file and just say, okay, I want to be cremated, or this is where I want to be buried, and this is the song I want to be played when I'm, during my ceremony. And so it's so important.
Yeah, I'm an only child, so I think something like that would be a wonderful gift for my mom to leave for me. I can't imagine what that would be like. Her and I joke, she wants to be cremated, and I always say, well, I'm just going to spread your ashes at all your favorite stores. But obviously I can't do that, but I have no idea what she wants me to do with them. And, I think that that's a wonderful gift someone can leave, which is, I've taken this off your plate. These are my wishes. And now you can, grieve and heal and not have to worry about it.
And you have family dynamics, and you have a daughter who might say, Mom wanted this, and and a son say, no, Mom wanted that. And to have it all done early is important.
Larger families, of course, those family dynamics play into everything. It's being an only child, I guess, can have a blessing and a curse, but not instance, I guess.
A large responsibility. Yeah,
definitely. Well, we've got some exciting things coming up this next week. So it's the summer. Everyone should get out and enjoy time with family, as much as you can. There's some great events out in the community. We've got a couple of my favorite farmers markets that we've shared before on a couple episodes. And then I encourage everyone to save the date of October 17th. It is the Parkinson's annual bingo event, Bags and Bauble. It's my favorite event they do every year. It's always so much fun. And I would recommend you guys to save that date or reach out to the organization and secure your tickets for that. It's such a fun event. As always, they have it at the vineyards. And who doesn't love a good dinner, bingo, and winning some luxury handbags?
Sounds fun. Sounds like a great time.
Yeah, definitely. Looking forward to it. So next week, we have a great episode. It's all about how to be proactive and not be reactive when it comes to your health and wellness. And we will be featuring a couple wonderful local health experts, and we look forward to bringing that topic to you.
See you then.
Bye.
Thank you.
Be sure to subscribe to our podcast and follow us on social media. You can also find more information and resources at www.theaginggamepodcast.com.